Boy, you've got to love springtime in Missouri. There's no time like the spring to get out and shoot some of your favorite homemade steel targets. And you know, the good thing about spring, too, is the Missouri General Assembly is in session. And there's a lot of great guys and gals in the General Assembly that care about your right to keep and bear arms. Two of them are Senator Eric Burleson and Representative Jared Taylor. They've filed the Second Amendment Preservation Act. It's the strongest gun rights bill in the country. It's designed to protect you and me from federal gun control laws. The Missouri Second Amendment Preservation Act uses the time-tested and constitutionally sound anti-commandeering doctrine to protect your right to keep and bear arms from federal overreach. And it does it in a simple way. It just simply says that the state of Missouri, none of its subdivisions nor public officials, can use any of its resources to aid or assist the federal government in enforcing its federal gun control laws. It says that the only gun control laws that will apply to Missourians are ones that Missourians put into statute. It's the same legal and constitutional framework that states like California have used to make themselves sanctuary states. But in this case, it's Missouri making itself a sanctuary state for the right to bear arms.
The feds cannot take over state discretion and say to local and state officials, law enforcement officials, you will help us enforce federal law. They need to do it on their own, and they need to pay for it on their own. You know, so California is emboldened, whether you think this is wise or unwise, it's emboldened now.
And that's exactly what Senator Burleson wants to do. He wants to embolden state officials to do their constitutional duty to protect your right to keep and bear arms. He'll give cover to the law enforcement officers that refuse to violate your rights by enforcing unconstitutional federal gun control edicts. The anti-commandeering doctrine is based on some of the most fundamental principles of our system of federalism, and it's buttressed by a series of landmark U.S. Supreme Court opinions that support the doctrine. All the way from 1842 to as recently as 2018, the Supreme Court has said that the states have the right to refuse to cooperate or participate in the enforcement of federal laws. In 1842, in Prigg v. Pennsylvania, Justice Joseph Story held that the federal government could not force states to implement or carry out the Fugitive Slave Act of 1793. By doing so, they protected the rights of many black Americans from being dragged into slavery. Then in 1992, in New York v. United States, Sandra Day O'Connor wrote for the majority saying that Congress may not simply commandeer the legislative process of the states. And then in Prins v. United States in 1997, the Supreme Court agreed with Sheriffs Mack and Prins that as state-level officials they could not be forced to participate in the Brady gun bill. Then in the well-known Obamacare case, NFIB v. Sebelius in 2012, the U.S. Supreme Court cited the anti-commandeering doctrine as to not only affirm the state's right to refuse to expand Medicare, but also to prohibit federal retribution through the withholding of federal funds. Then as recently as 2018 in Murphy v. NCAA, the court held that Congress can't take any action that dictates what a state legislature may and may not do, even when the state action conflicts with federal law. So why is the anti-commandeering doctrine so powerful? It's because the federal government lacks the resources to do its own work. It relies on state and local resources, including law enforcement officers and facilities and equipment, to do their job if they're going to do it in any wholesale fashion.
If the federal government limits guns in a state, will it need the assistance of state police to enforce those limitations? Yes, it will.
Sure.
And do the states have the right to refuse to enforce federal law that's against state public policy? Yes, they do.
Sure.
That's where we are on this.
That is where we are. And the reason a number of states are trying to come up with this new gun legislation is because they see Washington, D.C., and they're worried about a gun grab.
Correct. Now, the states, our home state of New Jersey, could not, for example, use the police to frustrate federal law enforcement, but it could say to state and local police, you will not cooperate. That will make federal enforcement of tighter federal gun laws nearly impossible.
All right, Judge Napolitano.
And since the anti-commandeering doctrine prohibits the federal government from forcing states to participate in the enforcement of laws that the federal government makes, the federal government resorts to bribing local officials with things like grants. Well, the Missouri Second Amendment Preservation Act prohibits by statute local governments from accepting grants that make as a contingency their participation in the enforcement of unconstitutional federal gun control edicts. The Missouri Second Amendment Preservation Act is not just a political statement. It has teeth that protect your right to bear arms. And those teeth don't depend on government to protect you from the government. The Second Amendment Preservation Act doesn't depend on a local prosecutor or the Attorney General to do his job before your rights are protected. It includes a private cause of action so that any citizen whose rights have been violated has the right to sue in civil court. What's more, sovereign and official immunity is stripped, so government actors can't claim to be above the law. So, is the Missouri Second Amendment Preservation Act anti-law enforcement? Just the opposite. It protects law enforcement officials who want to uphold their oath of office and their constitutional duty. It provides them legal cover to say no when their boss says you've got to do this or that against their conscience and against the Constitution. So when the Second Amendment Preservation Act becomes a Missouri statute, does that mean that all of a sudden we'll have criminals running the streets with machine guns and bazookas? Not at all. The fact of the matter is, virtually all of the types of firearms that are prohibited by federal law are also prohibited by Missouri law. Not much changes in that respect. What does change is that if a criminal is found in possession of an illegal firearm, he'll have to be charged under Missouri law, not federal law. Missouri laws made by Missourians for Missourians. Of course, it also means that if you don't like what's in Missouri law currently, you have a much better opportunity to make a change in that law because the seat of government in Jefferson City is much closer than the seat of federal government in Washington, D.C. That's the way the founders designed our system of federalism. If the Missouri Second Amendment Preservation Act sounds like something you can get behind, please don't hesitate to go to www.mofirst.org, where you can learn how you can help pass the strongest of all gun rights bills in the country.